Good afternoon, dear colleagues and dear participants. As Associate Dean of FGV Direito São Paulo, I would like to say that it's a great pleasure to have you all here to start this third week of the first University of Chicago Law School, FGV Direito Rio and São Paulo, in this forum in Law and Economics in Brazil. This online first forum in Chicago FGV fulfills, at least in part, the purpose of taking forth the joint initiative of our law schools to organize annual meetings on law and economics in Brazil. We believe this online forum is a good sample of what we expect to do face-to-face next year in Rio and São Paulo. I'd like to take this opportunity to thank my colleagues Omri Ben-Shahar and Todd Henderson from University of Chicago Law School, and my dear colleague Rodrigo Viana and Antonio Maristelo Porto from FGV Direito Rio. I'm grateful for all their energy and enthusiasm to organize this venture. Our special thanks to the Chicago and FGV teams that spared no effort to make this event happen in the best possible way. Before we start, I'd like to remind you that all statements expressed by Fundação Getúlio Vargas employees and guests in our online events and broadcasts exclusively represented their opinions and not necessarily FGV institutional position. We also reiterate that everyone present here agreed to participate in this event of their own free will, and they consented to be recorded in this broadcast, which will be posted later at FGV and Chicago's University official channels. I also like to remind you that it's possible to send comments, questions through a Slido link from the YouTube description. Please feel free to do so. Okay, this week we are debating the economic analysis of corporate and securities law. This afternoon, we will have a lecture by Professor Mariana Pagenda, my dear colleague from FGV Direito São Paulo. Professor Mariana Pagenda is a full-time professor of law at Fundação Getúlio Vargas Direito SP and director of its Center for Law and Economics and Governance. She is also a research member of the European Corporate Governance Institute and has taught as a visiting professor at Yale, Stanford, Columbia, and Penn law schools. She holds a LLM and a JSD degrees from Yale Law School. She is admitted to practice law in São Paulo and New York. Her scholarship, which has been published by leading law reviews, examines problems in corporate law, corporate governance, and contract law from an economic and comparative perspective. We would like to thank you very much, Professor Pagenda, for accepting our invitation to participate in such an initiative. Please, you have the digital floor. Thank you all again. Thank you.
Thank you, Professor Maria Lucia, for the introduction. Congratulations on this wonderful initiative. Law and economics is a central piece of legal education at FGV, and this is a wonderful forum to further develop the law and economics agenda in Brazil, and I very much look forward to next year's live edition. Meanwhile, I will share my presentation with you today. So this is the second meeting on corporate and securities law from an economic perspective. And I will continue in virtual dialogue with Professor Todd Henderson, who preceded me. He said in the last episode that the business corporation is mankind's greatest invention. That made me feel very good as a professor of corporate law. I even told my 7-year-old daughter who doesn't quite know what I teach or write about, that a very prominent professor had said that it is actually about mankind's greatest invention. I'm not sure if it's the greatest invention, but it's certainly a very important invention. And throughout my lecture today, I would like to emphasize the role of law and regulation in the success of that invention. Oops. Okay, so here I have Adam Smith, the famous father of economics, and he says that it is not from the benevolence of the butcher, the brewer, or the baker that we expect our dinner, but from their regard to their own self-interest. This is a very famous quote from Adam Smith. It has the very important insight that individual self-interest might lead to outcomes that are socially beneficial. We still have this insight as a critical one today. However, many people don't know that Adam Smith himself was skeptic about the emerging business corporations of his day. Those were the colonial companies of the time. He said that the directors of such companies, being the managers of other people's money rather than their own, were not expected to do a very good job. So negligence and profusion, therefore, must always prevail according to his view. So this is an early articulation of what law and economics scholars today call agency costs or agency problems, which is the idea that directors of a corporation might pursue their own interests instead of the interests of shareholders who actually gave the money to the enterprise. And that's evidently a problem. So Adam Smith was not enthusiastic about the business corporation, and yet the business corporation succeeded. So a critical question for us is, what did Adam Smith miss? And here I have a picture of Ronald Coase. Professor Henderson said that as an employee of the University of Chicago, he must quote or cite Ronald Coase. I'm bringing him up here because as a father of law and economics, he also has an answer to what Adam Smith missed. On the one hand, Coase pointed out that market contracting also has costs. So economic activity might be more efficiently organized under the hierarchical structure of firms. Coase also pointed out that in a world of positive transaction costs, which is the world we live in, the law has a very important role in achieving efficient outcomes and in the allocation of resources. And good laws can help in the reduction of transaction costs. And the claim here, again, will be that law and good laws have a key role to play in the success of the corporate form and in the development of capital markets. So I will approach the theme of corporate and securities law and economics from a comparative perspective. So my presentation will cover different grounds. First, I will explore from a fairly mainstream or conventional perspective, what does corporate law do? And in this respect, I will cover the key core legal elements of the business corporation and the core legal strategies of corporate law. Then I will turn to a more provocative question, looking at Brazilian institutions, and I will ask, does Brazil have a business corporation? The answer, of course, seems to be yes, but I will offer the provocative question, not really, showing that there are important discrepancies or distinctions between the Brazilian business corporation and the standard international form of the business corporation. And then I will inquire about why that is the case. And we'll explore to what extent or whether these different features of the Brazilian corporation might be deemed to be efficient from an economic perspective. And then building on current scholarship, I will ask the question of what does corporate law really do or should do? And here I will question what I call the modularity approach to corporate law and economics, which is actually a fairly standard approach to law and economics more generally, which is the idea that every area of law should be primarily concerned with only one efficiency objective, and that the objective for corporate law should be the reduction of agency costs. So here I will examine the core attributes of the business corporation, building on the anatomy of corporate law. It is today a classic comparative law book. I had the privilege of joining the 3rd edition of the Anatomy of Corporate Law in 2017. So this is the cover that you see. And also, I also included Brazil in the sample of jurisdictions analyzed by this book. So it is a comparative book, but instead of focusing only on distinctions or differences, the book also focuses on similarities among corporate laws around the world. And it notes something which is quite striking or remarkable, which is that large enterprises around the world take the form of the business corporation. And that the business corporation around the world has certain core attributes or elements. And those are legal personality, including the attributes of entity shielding and lock-in. I will talk more about that in a moment. Limited liability, delegated management under a board structure. This means that investors in a business corporation do not directly manage the firm, but instead delegate its management to a selected team of managers that take collegial deliberations under a board structure. The shares in those companies are generally transferable, and those companies are owned by investors, meaning that their shareholders are primarily in for the money and not for something else. This is in contrast to some of the early business corporations Professor Henderson told us about, those that fulfilled a public service or a public function in the early 19th century. I have actually studied those corporations and found out that in many such cases, those corporations were primarily owned by their consumers who invested in them, not because they wanted a financial return, but because they wanted to benefit from the public service provided by the firm, be it a road or even financing from a local bank. Today, however, business corporations that we are going to study are primarily owned by investors. One prominent law and economics or economic conception of the corporation is that the corporation is a nexus of contracts. So here you have the depiction of such a nexus. So a corporation serves as a nexus for contracts with shareholders, managers, lenders, workers, suppliers, and consumers. In my presentation, I will try to challenge or at least improve on this formulation in two respects. The first one is what will come next, which is the idea that for the corporation to serve as a nexus of contracts, certain legal attributes are essential. And those legal attributes, in fact, permit the corporation to serve as a nexus for contracts. So I'll talk here about the role of law in permitting the corporation to serve as a nexus for contracts. So one idea is that a very critical component offered by corporate law is asset partitioning, which is the separation between the assets of the corporation and those of shareholders. That can take different forms. The first and most famous one is limited liability, the idea that shareholders are not liable for corporate debts. Another dimension of asset partitioning is known as entity shielding, and it was developed by Hansman, Crackman, and Squire, which is the idea that corporations are not liable for shareholder debts. Finally, we have still another dimension, which Margaret Blair and Lynn Stout have called capital lock-in, which is the idea that shareholders cannot unilaterally withdraw assets from the firm. Said in another way, that there is some form of liquidation protection. So shareholders can only withdraw assets from the firm if liquidation is approved by a majority of shareholders and creditors are paid first. What is important here is that unlike limited liability, which probably could be achieved by contract alone, entity shielding and capital lock-in require law. Especially entity shielding binds third parties, it binds creditors of shareholders. So we need law to give corporations this very essential attribute for the functioning of shareholders. So a brief recap here before we move on. Law is an essential part of mankind's greatest invention. Not sure about the greatest, but it is indeed a very important invention. But this greatest invention creates agency problems, so much so that Adam Smith was a skeptic about the potential success of business corporations. The good news here is that law also helps mitigate agency problems. As sometimes I tell my students when I ask the question, what did Adam Smith miss? I say, well, he did not take my corporations law course or any other professor's corporations law course, because corporate law has an important role in mitigating this agency problems created by the corporate form. There are three forms of agency problems according to the anatomy of corporate law. The first one is the most well-known one since Adam Smith, and perhaps the most prevalent in the Anglo-Saxon tradition, which is the managerial agency problem, the one Adam Smith told us about, the idea that managers might manage the firm according to their own interests and not in the interest of shareholders. However, that is not the type of agency problems that prevails in most jurisdictions around the world, including Brazil. Most corporations in Brazil, as well as in many other jurisdictions outside the Anglo-Saxon world, have controlling shareholders, and those controlling shareholders are able to keep managers in a tight leash. So that means that the prevailing agency problem in those jurisdictions is the one between controlling shareholders and minority shareholders. There is, however, a third type of agency problem, which has to do with the attribute of limited liability, which is one of the core elements of the corporate form. And so you have the potential that corporations or shareholders might act in ways that are not in the interest of creditors. So you have the corporation creditor agency problem. There are, however, multiple strategies for protecting principles in the corporate context. So you might want to impose certain rules or prohibitions on managers or controlling shareholders. Take, for instance, the prohibition on insider trading. You may not trade on the basis of non-public material information. You might want to impose standards of conduct on directors or controlling shareholders, such as the fiduciary duty of care or the fiduciary duty of loyalty, the idea that directors should make decisions in the best interest of the company. You might have affiliations strategies by which the system provides disclosure to better inform entry and exit decisions in a firm. You might resort to a trusteeship strategy, such as the appointment of independent directors to avoid conflicts of interest. You may embrace up with executive compensation schemes that better align the interests of directors with those of shareholders. You might give shareholders the right to vote directors into office and vote them out of office. That is generally the case. It's a key attribute of investor ownership. And you might allow them to initiate or veto certain decisions. So this suggests that there are many ways by which corporate law may mitigate agency problems. And this is a very important, one very important idea is that different jurisdictions might mitigate agency problems through different strategies. This leads to a very critical insight from comparative law, which is that sometimes the same rules might lead to different results. And sometimes different rules, different strategies might lead to the same result of adequate investor protection. So there's some possibility of functional substitution. But another critical idea is that the effects, of course, of any given rule or standard might depend on the underlying institutional context, including, most critically, ownership structures, which are thought to have a critical impact on the way investors are protected. So the best rules for a firm with dispersed ownership are likely not to be the same as the best rules for a firm with a concentrated ownership. So this is a very important factor to bear in mind. Again, with playing with the idea of inventions, I'm bringing up this quote from Bernard Black in 2001, and he points out that the very fact that securities markets exist at all is actually magical in a way, because investors pay enormous amounts of money to strangers for completely intangible rights, whose value depends entirely on the quality of information that the investors receive and on the seller's honesty. He notes that internationally, this magic is rare, and it does not appear in regulated markets, meaning that law has a critical role to play in this magic. I bring this up because Brazil, for quite some time, especially in the 1990s, has struggled with the development of its capital markets, arguably because the law was insufficiently protective of investors. So this is a very important factor to bear in mind as we move the conversation along. In one very prominent study, in fact, by University of Chicago economists during the 1990s, Brazil was deemed to have the highest levels of private benefits of control worldwide, meaning that Brazil was the best place in the world to be a controlling shareholder. Conversely, the worst place in the world to be a minority shareholder, given that controlling shareholders appropriated so much of the firm's value. So this situation has changed somewhat in recent years, but it does suggest that investor protection remains a critical issue for Brazilian capital markets. I will now start the second part of the presentation, which, as promised, takes on the question, does Brazil have business corporations? It seems such a silly question at first sight. Actually, if we open Lei 6404, our corporation statute, will go check, 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 check. Of course, we have legal personality, limited liability, delegated management and the board structure, transferable shares, and investor ownership. What a silly question. I, in fact, spent most of my career writing about Brazil as if Brazil does have a business corporation. And that is the approach I adopt when discussing Brazil in the Anatomy of Corporate Law. And here I have a picture of the Portuguese edition of the book. However, I hear, so that is the view that Brazil does have a business corporation, is the view of the glass half full. What I want to do now is offer, for reflection purposes, the view of the glass half empty. So here it goes. The idea will be that the core elements of the corporate form in Brazil are far weaker than usually is. Moreover, such divergence is relatively recent. So here we're not talking about a certain stereotype about laws in developing countries, which are just antiquated and need to be modernized. We're talking here about recent developments in Brazil's corporate law. So Brazil used to have a business corporation in the past, but that is no longer so clear. And for Brazilian, for the Brazilian audience, I would like to stress that when I talk about business corporation, I mean sociedade anônima. I do not mean sociedade anônima with dispersed ownership, which is sometimes how the term corporation is used in the media. I just mean sociedade anônima, or the equivalent in various languages. So the idea here is that we could actually cast doubt on the presence of all of the core attributes of the corporate form in Brazil. But I will, in my exposition today, focus primarily on number 1 and 2, which are the attributes related to the central idea of asset partitioning that we talked about before, such an important prerequisite for the corporation to serve as a nexus for contracts, something that the law needs to give you. You cannot achieve this result easily by contract. And nevertheless, those elements have been disappearing from Brazilian law, as we shall see. So here, first, the idea of lock-in, which is the idea that shareholders cannot unilaterally withdraw assets from the firm. So at first impression, we'll find out that the corporation is a separate legal person under Brazilian law. There's a strong form of separation between the assets of the firm and its shareholders, and shareholders' ability to withdraw assets from the firm is limited. Of course, you might have a full judicial dissolution approved by court if the corporation cannot fulfill its purpose, or approved by a majority of shareholders, exactly what you're likely to see in any other country. And you also have statutory appraisal rights in case of fundamental changes. This is something that you do not see in every jurisdiction, but you do see in many of them. So it's not a peculiar trait of Brazilian corporate law. So we will conclude that Brazilian law on the books does provide for lock-in. However, it is settled case law, settled. In Brazil, there are so many issues that are so largely controversial, but at least in courts, this issue has been largely settled, that minority shareholders of closed corporations can request a partial dissolution at will. I say at will. Formally, the ground is a breach of effectio societatis, but usually it's quite easy to say, to prove a breach of effectio societatis with usually the idea that there is no longer affection or the will to be part of a joint organization. So it's a requirement that is very, very easily satisfied. Sometimes also the ground is the constitutional right of freedom of association. But the conclusion is very clear. Lock-in is, at least apparently, at least according to the court's decisions, gone for closed corporations. And there is even one recent decision extending the right to seek a partial dissolution to minority shareholders of a publicly traded corporation that, however, lacks liquidity. So this is quite a striking development in the evolution of corporate law in Brazil, and one that, to my knowledge, is unprecedented and has no correspondence in other jurisdictions. The second element of Brazilian deviation concerns limited liability. If you read the corporation's law, you'll find out that shareholders have limited liability. If you read the civil code, you'll find out that courts may pierce the corporate veil only in exceptional circumstances of commingling of assets or abuse. So there is nothing unusual so far. However, there are numerous exceptions to limited liability in special statutes and through case law. So limited liability is very often overcome in labor law. There are exceptions to limited liability concerning directors and officers and controlling shareholders of financial institutions. And there are also very broad exceptions to limited liability in Brazil's Consumer Protection Code and also in its environmental law. In fact, I'm here quoting from the Consumer Protection Code, but the provision in the environmental law is roughly the same. It says that courts may pierce the corporate veil whenever legal personality is in any way an obstacle to the compensation of harm caused to consumers. This is incredibly broad, and courts have said that the statute means what it says. So whenever limited liability would actually be helpful to shareholders, it does not apply. So this is quite noteworthy. There is more in terms of exceptions to asset partitioning under Brazilian law. There's a clear disregard of corporate boundaries within corporate groups through the very broad use from a comparative perspective of substantive consolidation in bankruptcy. That means treating the various corporations inside a group as an enterprise, as a single entity for purposes of bankruptcy proceedings. Even Brazil's recent anti-corruption law greatly mitigates asset partitioning by imposing joint and several liability of controlling shareholders, controlled companies, and affiliates for acts of corruption. So there are great exceptions to asset partitioning in Brazil. Let me just say a word about delegated management under a board structure, which is also weaker in Brazil. From the anatomy of corporate law, it is striking how the legal regime in Brazil is highly shareholder-centric. There's a greater array of decisions that shareholders can and or must make compared to other countries. So shareholders can decide on all businesses relating to the company's purpose. I'm here quoting the statutes. They must decide on business. They must decide on a bankruptcy filing. And while shareholders enjoy more power, boards, of course, enjoy relatively less power. And one striking and, of course, controversial feature of Brazilian corporate law is the idea that shareholder agreements can bind directors' votes, also something highly unusual from a comparative perspective. But then we come to a very interesting question, which is what explains what called decorporatization in Brazil, or the weaker version, the weaker attributes of the corporate form that we see in Brazil. One answer is that no, there is no explanation to that. Brazilian law is just crazy and must be urgently reformed. So actually, I think many scholars adhere to this view. But what I want to propose here is to make us think further and think about whether there are reasons, just general reasons, or reasons relating to the particular institutional environment in Brazil that may explain why Brazilian corporate law has evolved in the way it has. And here I'm talking about both efficiency reasons, which is the principal type of analysis that we do in law and economics courses, and also issues of distribution, which have traditionally been ignored in law and economics courses, but there are new arguments, including from the University of Chicago, that we should include distributive analysis in normative analysis of legal rules. So there are three versions of the efficiency argument. What is that? The idea that the weakening of the corporate attributes that we see in Brazil is actually efficient. One idea, perhaps quite provocative, is that Brazil has the efficient regime everywhere, meaning that Brazil got it right, other countries got it wrong. And let me give you a taste of that. For a long time, law and economics scholars in the United States, including scholars affiliated with the University of Chicago, such as Richard Posner, have questioned the efficiency of limited liability with respect to non-adjusting creditors or non-consensual creditors, such as tort victims. Because if you have limited liability with respect to a contractual creditor, the creditor can then adjust the contract terms to account for greater risk. But if you have limited liability with respect to non-adjusting creditors, such as the victims of taxi cabs Professor Henderson told us about, that is not only unfair, but it's also potentially inefficient, given that cabs might take insufficient precautions, knowing that the costs of accidents will be borne by others. So with respect to environmental law, and perhaps even consumer and labor law, if you think that even though consumers and workers have a voluntary relationship with the firm, but might be unable to price the risk of firm failure, Brazil might have the efficient regime, actually the dream of many law and economic scholars, including my own supervisor, Henry Hansman, who has defended the idea of unlimited liability for corporate torts. So this is one idea here. I do not want to argue. In fact, I cannot argue that all aspects of unlimited liability under Brazilian law are efficient. For instance, some courts sometimes impose joint and several liability, responsabilidade solidária on shareholders, including minority shareholders. That would not be efficient. But if we do away with the requirement of joint and several liability, that could be a response actually defended by various law and economic scholars worldwide. A second argument, perhaps more persuasive to a broader audience, is that Brazil's regime is efficient in view of its weak institutional environment. So the idea here would be that, to take one example, the example of Lockheed, maybe if you are in a country that sufficiently protects minority investors, it makes sense to keep them locked in the firm. But possibly if you are in a context that does not provide for sufficient levels of investor protection, which seems to be the case in Brazil, the case for offering an alternative remedy, say through partial dissolution, is comparatively stronger. To take another example, scholars from other countries have also suggested that perhaps financial institutions should be subject to unlimited liability, given the externalities they oppose through the creation of systemic risk. One could raise the counter argument that you do not need unlimited liability because you have bank regulators. However, if bank regulators do not do such a great job for various reasons, you might want to have limited liability potentially compensate for a weaker regulatory apparatus. And it seems that unlimited liability in the banking sector in Brazil was an intended, purposeful regulatory strategy on the part of the Brazilian government. A third idea is that the dwindling of one of the attributes weakens the case for the other. So if Brazil weakens, say, the attribute of lock-in for whatever reason, then the case for limited liability would be also weaker. The idea is that there's some complementarity between this corporate attributes. So if one of them is gone, the case for the others, it's kind of a domino effect. The case for the others is also weaker. So think about it. One thing is to tell a minority shareholder that he or she is locked in the firm, even though she no longer wants to be a shareholder in a closed corporation and she cannot find anyone to sell the shares to. if she has limited liability. However, if she has unlimited liability, the case for partial dissolution, of course, is comparatively stronger. At the same time, the case for limited liability is stronger in a scenario that does not recognize partial dissolutions, because if there is a partial dissolution, what happens is a shareholder gets paid before creditors do. So one way to think about it is, in a way, unlimited liability might compensate for weaker creditor protection generated by our liberal regime of partial dissolutions. It might also be the case, of course, that the weakening of corporate attributes in Brazil is not due to efficiency considerations, but to concerns about distribution. That's not usually the type of analysis considered in law and economics courses, but that's increasingly accepted and provide food for thought, especially in countries such as Brazil, in which inequality is and has always been a dramatic concern. So it might be the courts, in fact, have weakened the corporate attributes to help have-nots, such as minority shareholders, workers, consumers, taxpayers, or victims of environmental harm. I will now switch to my third question, which is, what does or should corporate law really do? So here I would like to cast some doubts on the mainstream view that I have offered before. The conventional answer about what corporate law does and should do is to mitigate agency costs. And we see that. Agency costs are so important. They're the reason why Adam Smith hated corporations. So it's very important that corporate law, for corporate law to address agency costs. However, the focus on agency costs by corporate law scholarship is, in fact, just one manifestation of what I have called the modularity approach to law and economics. What do you mean by modularity? Well, we have different fields or segments, and each of them has one objective. So it's an idea of functional specialization. And most of law and economics scholarship operates that way. So the objective of corporate law would be to reduce agency costs, or put it in another way, to promote investor protection. The key objective of antitrust law would be to improve consumer welfare. The key objective of bankruptcy law would be to maximize firm value for the benefit of creditors. The key objective of contract law should be to reduce transaction costs. And any concerns about distribution should be left exclusively to the system of tax and transfer. And what I'd like to suggest here is that it is the case that those fields are not as pure in terms of only one objective as law and economics scholarship has generally assumed. And there is now a growing attack on this modularity approach to law and economics, including corporate law and economics. And the way that attack takes place in corporate law is through the debate, which is very old, but is now very new again, which is the debate about whether corporate law should focus only on the protection of shareholders or should also address the protection of other stakeholders. So there are, of course, two dimensions. This corporate law, as observed in most jurisdictions, aim exclusively to mitigate agency costs. I would suggest that that is not the case, not only because, say, some jurisdictions, most notably Germany, offers board seats to employees in a way to also promote worker protection. So that is well known. But even in the United States, I would argue that corporate law as we see it, not as scholars want it, is also shaped by other considerations, such as economic protectionism. So Professor Todd Henderson told us last class that takeovers, hostile takeovers, are a very helpful strategy to curb managerial agency costs, but managers have lobbied local legislature to introduce anti-takeover statutes. Why did they do it? I mean, one idea, which I think it was Professor Henderson's key idea, is that that's just an instance of inefficient political capture. But it's also possible to interpret these cases as protectionist devices, because most of those legislations were introduced when a local state target, when you had local workers, local managers, a local industry subject to an acquisition threat by a foreign company. And that form of local protection, I think, was very much a consideration in the enactment of anti-takeover statutes. I have pursued this theme more broadly and have showed in my scholarship that there is a grip of nationalism on corporate law, that around the world, what we have seen in those US states is prevalent. A lot of many corporate law reforms are actually enacted in response to foreign takeover threats in order to achieve nationalist objectives, not to reduce or increase agency costs, which is the conventional lenses of law and economics. And then you have the highly contested normative question of the day: should corporate law aim exclusively at the mitigation of agency costs? What about the environment, climate change, gender equity, racial issues, inequality, systemic risk, and the list goes on? What about those questions? And here I'm going to provide you with the orthodox response about why corporate law should care exclusively for shareholders. The first notion is that shareholders very much need protection. They are residual claimants. What do shareholders have? Well, they have a right to share in the distribution of profits if there are profits, and if managers decide to distribute those profits. That's a very weak right. They are generally, in other jurisdictions, locked in the firm. They cannot request a partial dissolution. So they absolutely need protection. Otherwise, why would they invest in firms? Other parties, however, can be protected in other ways. So creditors, suppliers, consumers, they can get protection by contract. And their contracts are easier to write because many of them are fixed claimants. They're easier to write than the potential contract between a corporation and a shareholder, given their residual claimant status. Other parties that have no contractual relationship with the firm, so potential victims of traffic accidents or environmental harm, or if you think about the concern about systemic risk in financial institutions, well, the interests of those parties can and should be protected by state regulation. Besides, there is also a problem that Professor Henderson mentioned, which is the too many masters problem. If directors are supposed to serve everybody's interest, then it's very hard to hold them accountable with respect to any one of them. So those are the arguments for, you may call a shareholder value or shareholder-centric approach of corporate law, or a modular approach by which corporate law should focus exclusively on the mitigation of agency problems. What we have today, however, what we have today, however, is the idea that we may not be able to rely on number 3. But what if we know that state regulation, as we know it, as we see it, the real one, not the ideal one, but the real one, does not sufficiently protect external stakeholders? What if, let's suppose that is an abstract question, what if regulators around the world are not doing enough to fight climate change. Should that then be an argument for a less focused, less specialized approach to corporate law and the embrace of broader efficiency objectives beyond the protection of investors? So this is precisely the question of the day. I will not answer it. Instead, I will launch, we're approaching the end, and I'll launch my second and last attack on the vision of the corporation as a nexus of contracts. So I have the same, I'm sorry. So I have the same depiction here, but I will show what was missing from it. So the state was missing from it, right? So the state was entirely missing from the nexus of contracts view of corporations. But we know that state benefits and state disadvantages, state regulation, state taxation, that is a key element in the life and death of firms. And yet it was completely absent from the nexus of contracts conception. There was no mention of the relationship between corporations and non-contractual stakeholders. We talked about that. And no mention of the relationship between corporations and the state. But I will claim now that the relationship between corporations and the state is a key driving force behind the use of the corporate form today. So here's one question. Have you asked yourself that question? I certainly have asked myself that question, which is, why do large corporations have so many subsidiaries? I don't know if you know this, but many large corporations have hundreds or thousands of subsidiaries. Many, if not most of them, most of which are wholly owned. So it's not to gather additional investment. They're wholly owned by the parent company. So why is it that we see so many corporate subsidiaries? So the conventional answer would be, it is because of asset partitioning. We saw what asset partitioning is. So those subsidiaries would have separate assets, and that's helpful because that could lead to a lower cost of credit or even cost of capital to that company, because it would lower monitoring costs. You could have creditors lending to those companies that are specialized in that particular business. So if you lend to a hotel company, you're not contaminated by a sister firm that is in the healthcare business. You can be a creditor that specializes in lending to hotels, and then you can offer a better interest rate because your monitoring costs are lower. So this is a fine explanation. I tend to like it, except that real world institutions often contradict this theory. And why is that the case? The reason is that cross guarantees inside business groups are prevalent in the real world, meaning that many companies give guarantees to one another. What does that mean? That means that companies undo asset partitioning by contract, because if you guarantee your sister company's obligations, then truly the reduction in monitoring costs no longer holds, because if the hotel company guarantees the debt of, what was the other company about? A healthcare company, then the creditor would need to know about hotels and healthcare, both companies, both industries. So asset partitioning cannot be the case. And what is the reason then? Well, it's a claim that I coined, the term that I coined, which is because of regulatory partitioning. In addition to the separation of assets, constituting a new corporation means that you have a new legal person that is separate for purposes of the imputation of legal rights and duties in ways that have nothing to do with asset partitioning. So I'll give you one example. So a subsidiary of Brazilian firm Odebrecht is suing, what country? Is it Peru or Colombia? Now I forgot. Based on a violation of a bilateral investment treaty. But here's the mystery. Odebrecht is a Brazilian business group, but Brazil is not a party to any bilateral investment treaty. So how can they be suing our fellow Latin American government based on such a treaty? Well, because they were doing business in that country using a Dutch subsidiary, and the Netherlands is a party to a bilateral investment treaty. So what does this mean? Well, this means that actually many, if not most, of the corporate subsidiaries we see in the real world are formed for reasons of regulatory partitioning. You are able to create a separate nexus for regulation. And that is very helpful with respect to regulatory benefits, such as the ability to sue based on a bilateral investment treaty. And it's incredibly prevalent with respect to tax regulation. You're able to constitute firms in countries that offer more favorable tax rates. So the claim here is that many subsidiaries are formed for reasons of regulatory partitioning and not asset partitioning, meaning that their key reason for their existence is not the formation of new contracts, but is the tailoring with their relationship with the state. And that is highly consequential because if the state is involved, you have the interests of a greater number of stakeholders involved. And that may require you to look at these issues from a different angle than that generally prevailing in a typical contractual or private law field. So I'll conclude, I'll conclude by saying that law matters critically for the success of corporations and capital markets. Investor protection is absolutely critical, but the question of the day is it enough? And the institutional conditions of developing countries may impact the efficiency of corporate law rules and doctrines. Here you have my email. Thank you very much. And I look forward to any questions you might have.
Thank you so much, dear Professor Mariana, for this very profitable lecture. I really enjoy. I hope our audience too. Now, Thais, our researcher, please, will take the audience's questions. Thais, please go ahead.
Hi, good afternoon, everyone. So our first question is from an anonymous person. He or she asks, are courts in Brazil well equipped to tackle the question of the regulatory aims of corporate law? And what about Congress?
Okay, so this is a very, very good question. If courts are well equipped, well, I don't think, my personal view is that courts are not generally well equipped, and that some role for the legislature is quite important. Brazil's corporate law is the corporation statute, Lei 6404, is quite curious in its approach to the goal of corporate law. One might argue that that approach is potentially contradictory or inconsistent. On the one hand, if you read about directors and controlling shareholders' fiduciary duties, you'll find a strong stakeholder orientation in the law. So the statute talks about the social function of the corporation, of duties of controlling shareholders to care about the interests of the employees, the community, and even the national interest. So certainly there is, in terms of the content of fiduciary duties, a clear stakeholder orientation in the statute. However, we However, Brazil's corporations law also gives a significant amount of power to shareholders, more so than in any other jurisdiction I know. So then you have the question, if shareholders have so much power, how likely is it that the interests of other constituencies will be protected, especially in a system that has not been characterized by enforcement of fiduciary duties generally and especially, and this is a problem plaguing other jurisdictions as well, enforcement of duties to other groups beyond shareholders, given that under corporate laws, only shareholders may sue. So we have this contradictory approach in the statute, which might lead one to think that actually the shareholder orientation of Brazilian corporate law prevails over stakeholder rhetoric. However, it is also the case that under current Brazilian law, and here I'm talking about the recent change to the introductory law for Brazilian law, Lei de Introdução ao Direito Brasileiro, that says that when judges make decisions and other administrative officials as well, they should not decide based on abstract principles, but they also should attend to the consequences of these decisions. So in that particular way, I think the Brazilian legal system is demanding judges to adopt the type of consequentialist reasoning that is quite prevalent in law and economics. And although I think that type of consequentialist reasoning is very useful and very important, I do have great concern for, I think, the concern raised by the question itself, which is challenges in institutional capacities for judges to make those decisions. So my particular preference in terms of what I think is most socially desirable would be for judges generally to respect choices by the legislature in that respect.
So our second question is from Antonio. He asks, do you believe procedural rules have an important impact in the development of case law about fiduciary duties? And if so, how could the Brazilian system be improved?
Okay, so I think they have great significance. I do agree with the spirit of the question. So one very central theme in corporate law and economics and comparative corporate law and economics is that you should care not only about the laws on the books, but also about issues of enforcement. And enforcement has to do with the general challenges in terms of duration of proceedings, cost of proceedings, of the decision maker's expertise. But in the case of corporate law, it also has to do with various procedural challenges to bringing lawsuits. And there are various such challenges in Brazil. And I believe that those procedural rules greatly discourage, from a cost perspective, the bringing of such suits. So I do believe that procedural reforms are warranted to create greater incentives for private enforcement of corporate law as one of the strategies for the enforcement of fiduciary duties, as a strategy for the mitigation of agency costs.
So I think we don't have any more questions at the moment. So I'll ask Professor Maria Lucia to end the presentation with the.
Okay, I do hope that you have enjoyed this great opportunity, and I would like to invite you all for our next session. Will be this next Tuesday at the same time, 3 p.m. Chicago time and 5 p.m. São Paulo real time. Once again, thanks so much, Professor Mariana Pragenda, Rodrigo and Thais and all the audience, and see you next week. Thanks so much.